Exercise 1. What was once a dispute between landlord and tenant for the eviction of the tenant from the premises in dispute ended into a consent order way back in the year 2023. Unfortunately, the said consent order gave rise to a bitter civil dispute between the parties, which has now landed in this court after the suit was dismissed by the Court of Civil Judge. Full stop. However, the decree so passed was reversed by the High Court. This is how the parties are now before this court. The landlord applied for the eviction of the tenant on the ground that the house in question was in a dilapidated condition which required demolition and reconstruction. The suit was initially contested by the tenant, where the issues were framed and out of which two issues were relevant and important: whether the house in dispute is in a dilapidated condition, unfit for habitation, and requires demolition and reconstruction, and whether the landlord requires the said house for his bona fide personal use. In the said suit, on one of the dates fixed, the landlord appeared in the court and stated that there has been a settlement between the parties and the tenant has accepted to deposit a sum of rupees 12,000 in the court. If the amount is so deposited on or before the aforesaid date, the application of the landlord shall be deemed to be dismissed, and on failing to do so, the landlord's application would be deemed to be allowed. The tenant also appeared before the court on the said date and accepted the settlement. He stated that in case he fails to deposit the aforesaid amount on or before the date fixed, he shall vacate the house and go down, and in the event of him depositing the same, the application of the landlord shall be deemed to be dismissed in terms of the aforesaid settlement, and as per statement of both the landlord and tenant, the court of rent controller passed an order allowing the application of the landlord conditionally. It has come on record that the special leave petition of the landlord against the above order also stood dismissed, and nothing in detail to that effect has been brought on record. In short, the consent order between the landlord and the tenant become final and conclusive, despite the fact that there was no eviction order against the tenant or any positive direction in his favor. He moved an application for the execution of the consent order which came to be allowed by the rent controller, wherein it was directed that the name of the tenant be entered as owner in possession of the disputed premises by making corrections in the relevant records. Aggrieved by the aforesaid order of the court, the landlord preferred a civil revision by contending that there could have been no execution of the consent order at the behest of the tenant, as his application for eviction of the tenant stood dismissed, and that the court could not have ordered for recording the name of the tenant as owner in possession of the disputed premises. The civil revision was allowed by holding that in the meantime the building had collapsed and nothing remained on the spot which could be recorded in the name of the tenant. Therefore, in the end, the court held that the remedy of the tenant was not by way of an execution petition, and the order of the rent controller was not sustainable in the eyes of law. After having lost in the execution proceedings, the tenant filed a suit for permanent mandatory injunction. The appeal of the tenant also met with the same fate.